All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good afternoon and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Good afternoon, Your Honor. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Nasim Haradinaj.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Thank you, Your Honor. On behalf of the Specialist Prosecutor's Office are present today myself, Valeria Bolici, prosecutor with the SPO, and with me are Nathan Quick, legal officer, and Angel Langenberg, case and evidence management assistant.
Thank you, Madam Prosecutor. Now I turn to the defense, please. Mr. Rees. Microphone.
I appear on behalf of Mr. Gucati as Jonathan Ellison Rees, Queen's Counsel. I'm assisted by co-counsel Mr. Hugh Bowden, who sits to my left.
Thank you, Mr. Rees. And for the record, I note that your client, Mr. Gucati, is present in the courtroom. Now I turn to the registrar, please.
Good afternoon, Your Honor. Fidel Madonlin, Registrar.
Thank you, Madam Registrar. And for the record, I'm Nicholas Guillou, pretrial judge for this case. The accused is appearing today before the specialist chambers following the indictment confirmed against him on 11 December. Mr. Gucati, I already asked you to identify yourself during your first appearance in September, so I will move straight to the procedural history of the case. On 24 September 2020, I issued an arrest warrant against the suspect, having found grounded suspicion that Mr. Gucati is criminally responsible for the following offenses: intimidation during criminal proceedings, retaliation, and violation of the secrecy of proceedings. The suspect was arrested in Kosovo on 25 September 2020 and was transferred to the detention facilities of the Kosovo Specialist Chambers in The Hague on the same day. On 11 December 2020, in my capacity as pretrial judge, I confirmed the indictment submitted by the Specialist Prosecutor against the accused, charging him with the crimes of Count 1, obstructing official persons in performing official duties by serious threat; Count 2, obstructing official persons in performing official duties by participating in the common action of a group; Count 3, intimidation during criminal proceedings; Count 4, retaliation; Count 5, violating secrecy of proceedings through unauthorized revelation of secret information disclosed in official proceedings; and Count 6, violating secrecy of proceedings through unauthorized revelation of the identities and personal data of protected witnesses. The confirmed indictment was served to the accused on Monday, 14 December. Now, allow me to explain the specific purpose of this initial appearance for the benefit of the accused, of those joining us in the public gallery, and those following the proceedings online. Today's hearing is not a trial. No evidence will be presented or debated, and the guilt or innocence of the accused will not be discussed or debated. The purpose of this initial appearance is regulated by Article 39 of the law and Rule 92 of the rules. According to these provisions, as pretrial judge, I shall have the charges in the confirmed indictment read to the accused in a language he understands and speaks. Confirm that the accused understands the indictment. Satisfy myself that the rights of the accused, in particular his right to counsel, are respected. Inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or plead not guilty on each charge set out in the indictment. If the accused wishes to do so, he may immediately admit guilt or plead not guilty. And finally, I shall also set other dates as appropriate in performing my functions as pretrial judge. I expect the parties to adhere to these matters, which I will address in turn. Should either party wish to discuss any other matter not expressly foreseen in the context of the initial appearance, they are invited to do so in writing by making a filing before me. Mr. Gucati, first, may I ask you to confirm that you have received the confirmed indictment dating 14 December 2020 in a language that you understand and speak?
Yes, I have received it.
Thank you, Mr. Gucati. I will now ask Madam Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39 of the law and Rule 92. Madam Court Officer, please proceed.
Thank you, Your Honor. In the confirmed indictment, the Specialist Prosecutor charges Mr. Hisni Gucati with Count 1, obstructing official persons in performing official duties by serious threat punishable under Article 401(1) and 5 of the Kosovo Criminal Code and Article 15(2) of the law. Count 2, obstructing official persons in performing official duties by participating in the common action of a group, punishable under Article 401(2) to 3 and 5 of the Kosovo Criminal Code and Article 15(2) of the law. Count 3, intimidation during criminal proceedings, punishable under Article 387 of the Kosovo Criminal Code and Article 15(2) of the law. Count 4, retaliation, punishable under Article 388(1) of the Kosovo Criminal Code and Article 15(2) of the law. Count 5, violating the secrecy of proceedings through unauthorized revelation of secret information disclosed in official proceedings, punishable under Article 392(1) of the Kosovo Criminal Code and Article 15(2) of the law. And Count 6, violating the secrecy of proceedings through unauthorized revelation of the identities and personal data of protected witnesses, punishable under Article 392(2) to 3 of the Kosovo Criminal Code and Article 15(2) of the law. These offenses were committed between at least 7 and 25 September 2020. In relation to these offenses, there is a well-grounded suspicion that Mr. Hisni Gucati is criminally responsible pursuant to Article 16(3) of the law for A. Committing the offenses under counts 1 to 6 pursuant to Article 17 of the Kosovo Criminal Code. B. Co-perpetrating with Mr. Nasim Haradinaj and others the offenses under counts 1 and 3 to 6 pursuant to Article 31 of the Kosovo Criminal Code. C. Inciting the commission of offenses under counts 1 to 6 pursuant to Article 32(1) of the Kosovo Criminal Code. D. inciting the offences under counts 1 to 6 pursuant to Article 32.2 of the Kosovo Criminal Code, and those offences were attempted. E. Inciting the offences under counts 1 to 3 and 6 pursuant to Article 32.3 of the Kosovo Criminal Code, and such offences were neither committed nor attempted. F. Assisting in the commission of the offences under counts 1 to 6 pursuant to Article 33 of the Kosovo Criminal Code. G. Agreeing to commit with Mr. Nasim Haradinaj and others the offences under counts 1 to 6 pursuant to Article 35 of the Kosovo Criminal Code, and or H. Attempting to commit the offences under counts 1 to 4 and 6 pursuant to Article 28 of the Kosovo Criminal Code. Thank you.
Thank you, Madam Court Officer. Mr. Gucati, I wish to remind you that this is not the time to contest the charges, but simply to acknowledge that you understand the charges. You will have ample opportunity to challenge the charges with the assistance of your counsel. Mr. Gucati, did you understand the charges contained in the confirmed indictment as read out to you by Madam Court Officer?
Yes, I understood them.
Thank you, Mr. Gucati. Now, let me inform you of your rights before this court. The law on the specialist chambers and the rules of procedure and evidence guarantee you a number of rights. I will read out the most important ones. First, you shall be presumed innocent until proven guilty beyond reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing subject to any measures ordered for the protection of victims and witnesses. You have the right to be informed promptly and in detail in a language which you understand of the nature and cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense and to communicate with the counsel of your own choosing. You have the right to be tried within a reasonable period of time. You have the right to be tried in your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to examine or have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf. You have the right to have the free assistance of an interpreter if you cannot understand or speak the language used in the court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. You also have the right to make unsworn statements relevant to the case, and you may appear as a witness under oath. You have the right to lodge preliminary motions, to challenge the jurisdiction of the specialist chambers, to allege defects in the form of the indictment, and to seek the severance of indictment. You have the right to receive, within 30 days of today's hearing, the supporting material to the indictment submitted for confirmation. You have the right to receive all statements of witnesses whom the specialist prosecutor intends to call to testify at trial in the language you understand and speak, namely Albanian. You have the right to receive immediately any information which may reasonably suggest your innocence or mitigate your guilt or affect the credibility or reliability of the specialist prosecutor's evidence as soon as the information is in its custody, control, or actual knowledge. You have the right that all material and relevant evidence or facts in possession of the specialist prosecutor be made available to you before the beginning and during the proceedings. This right is only subject to restrictions which are strictly necessary and when any counterbalancing protections are applied. You have the right not to be detained for an unreasonable period prior to the opening of the case, to request review of decisions on your detention, and to appeal such decisions directly before the Court of Appeal. You have the right to appeal directly before the Court of Appeal a decision on preliminary motion challenging the jurisdiction of the specialist chambers. And you have the right to seek leave to appeal other decisions. Mr. Gucati, you heard the most important right that you enjoy in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Yes, Your Honor.
Thank you, Mr. Gucati. I wish to inform that according to of the law, you may not represent yourself because you are currently in detention. Representation by specialist counsel is therefore mandatory. It is my duty as pretrial judge to ensure that your right to counsel is respected. To this end, I have noted the registrar's filing informing me of the assignment of counsel. I take from the registrar's report and from your counsel submissions today that you are represented not only for the purpose of this initial appearance, but for the entire duration of the proceedings in accordance with Section 14 of the Directive on Counsel. Mr. Gucati, can you confirm that Mr. Rees has been assigned for the entire duration of the proceedings?
Po.
Yes.
Thank you. It follows that the accused is presently represented by counsel. I will now turn to the possibility for the accused to enter a plea, if any, in accordance with Rule 92. Mr. Gucati, within 30 days from today, you will be called upon to admit guilt or plead not guilty on each charge in the confirmed indictment. If you wish to do so, you may choose to immediately admit guilt or plead not guilty. I would therefore like to ask you, Mr. Gucati, if you have had the opportunity to discuss the charges in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this time. If this is the case, I invite you to stand up while you plead.
Para sa deklararon
Before I enter a plea, allow me, Your Honor, 2 minutes of your time to make a short statement.
un Hüsnü Gucati
I, Hüsnü Gucati, and my comrades in arms have protected and defended the thresholds of our homes and our homeland. And as a result, I got wounded on the 3rd of June 1999. And today I am a war invalid of the Kosovo Liberation Army. We did not invade Serbia. We are innocent, we are not guilty. I have the right to be free, and I have the right of freedom of expression and the right to express my own opinions it is my right, and so that in a lawful way I defend the values of the Albanian nation and of the Kosovo Liberation Army. And I will continue to defend these values up to the end. Your Honor, in relation to all the counts that were read to me a little while ago, I feel not guilty. And I'm completely not guilty.
Thank you, Mr. Gucati. Just one small clarification. It's an issue we had before with the translation, because in English it is translated, I feel not guilty. Can you confirm that you plead not guilty for the record?
Your Honor, I plead not guilty to all the charges. Thank you.
Now, let me move to the working language of the proceedings. In the scheduling order for this initial appearance, I decided that further to my previous decision as a single judge, the working language for these proceedings will be English. I informed the parties that all directions and instructions set out in the decision of 29 October 2020 shall remain valid for the pretrial proceedings. At this point, I would like to ask the parties whether they have other issues they would like to raise. I remind the parties to give prior notice should any submission require the disclosure of confidential information so that appropriate measures may be taken. Madam Prosecutor.
No issues to raise for the Office of the Prosecutor. Thank you.
Thank you, Madam Prosecutor. Counsel.
Two matters, Your Honour. The first is in relation to the date of the status conference. Your Honour did ask for oral submissions at today's hearing in relation to that date, and in particular had given advance notice of the 7th of January, a Thursday, as being a potential date for that status conference. Unfortunately, because of professional commitments, I'm not available for that date, Your Honour. But I would be available, as would Mr. Bowden, the following day, on the 8th of January. I have previously discussed the matter with newly appointed counsel for Mr. Haradinaj, and I understand that the 8th of January would be convenient both to he and also indeed to the Specialist Prosecutor's Office, for which I'm grateful for Miss Bellici's indication in relation to that date. So I would ask, in relation to that status conference, Your Honour, that the 8th of January be the date for that matter. The other matter I wish to raise is in relation to the review of detention, which is due by the 27th of December. In accordance with Your Honour's previous direction, we have submitted today written submissions. They were uploaded earlier on this afternoon to the legal workflow system. At the conclusion of those submissions, paragraph 31 to 34, we have requested there be an oral hearing in relation to that review. Your Honour's earlier direction in relation to the submission of written submissions provided that both the SPO and indeed Mr. Gucati and Mr. Haradinaj file their written submissions effectively simultaneously on today's date. We accordingly have not had any advance notice of the submissions on the review of detention that are made by the Specialist Prosecutor. Obviously, detention concerns a fundamental right of Mr. Gucati, namely his right to liberty, and the review concerns the issue of the ongoing deprivation of his liberty. The burden in relation to continuing detention sits with the specialist prosecutor to justify continued detention. And as you have previously stated, Your Honour, in earlier directions, you have acknowledged that Mr. Gucati has the right to be provided with all essential information in order to be able to obtain an effective review of his detention. And we would submit that advance notice of the specialist prosecutor's submissions with an opportunity to comment thereon would fall within that category of all essential information available. It is our submission that an oral hearing would provide Mr. Gucati with a fair opportunity to respond orally to the written submissions made by the specialist prosecutor, and I add that it would also allow counsel for Mr. Haradinaj to make some submissions, albeit oral, in relation to the same issue. It also would, of course, allow each party to directly respond to any questions that Your Honour has and to assist in the just and effective determination of the review. We have proposed, if Your Honour is minded to grant an oral hearing, we've proposed that a video link hearing could be held on either Monday, Tuesday or Wednesday next week, the 21st to the 23rd of December. That is our request for an oral hearing on the issue of the review of detention.
Thank you, Mr. Rees. Madam Prosecutor, on this last request, and we'll come back to the status conference after that, but first on this last request by Mr. Rees, please.
Yes, thank you, Your Honor. I observed that the defense counsel has been put on notice since the issuance of the pre-trial judge order for submission on the review of detention since the 9th of December 2020 that the parties were requested to file their submission on detention simultaneously. Hence, if the counsel had an idea that he would have wished to ask for a differentiated deadline in presenting the party submission, he could have raised the matter earlier. In this respect, an oral hearing, according to the Specialist Prosecution Office, is not necessary at this stage, considering that both parties have presented their submission in writing and that all matters are before the pre-trial judge for the issuance of its decision. I note that the Court of Appeal, in its recent decisions of the 9th of October 2020, when Mr. Gucati's appeals on the single judge decision on application for bail was rejected, also noted that convening a oral hearing on detention matter is a discretionary matter, and that it may be regarded as unnecessary when, as in the present case, the information before the court is sufficient to enable the issuance of a decision. Thank you.
Thank you, Madam Prosecutor. Mr. Rees.
Just very shortly, of course, in the Court of Appeal, the appellant, Mr. Gucati, as he was before the Court of Appeal, did have the opportunity to reply in writing to the response to the appeal that had been submitted by the Specialist Prosecutor before the Court of Appeal panel reached its decision. We do repeat and maintain the request for an oral hearing, proposing the video link hearing on one of the 3 dates next week, Monday to Wednesday. An alternative is an opportunity to provide a response to the submissions made in writing by the Specialist Prosecutor before Your Honour reaches the decision on the review. I raise that because we are in a different position procedurally to that which was before the Court of Appeal panel.
Thank you, Mr. Rees. On this matter, I'll issue a decision in writing this afternoon or Monday morning at the latest. I will now want to address the issue of the status conference that you raised, Mr. Rees, especially concerning the date. It has been indeed my intention to schedule it on Thursday the 7th. The purpose will be to review the status of the case and to organize exchanges between the parties and ensure expeditious preparation for trial. A question, Mr. Rees, if it were to be scheduled on Friday the 8th, would it be possible both morning or afternoon?
It would. We will, in the first instance, be asking to attend remotely both counsel and indeed Mr. Gucati. We were nevertheless going to ask the court to consider an afternoon listing, so that if nearer the time it became possible to attend in person, we would seek to do that. And an afternoon listing would accommodate travel in those circumstances. But given the current situation regarding COVID restrictions and the like, in the first instance, we will be asking for the court to permit remote attendance for both counsel and Mr. Gucati. And in the circumstances, we would be available for both morning and afternoon listing on that date, the 8th of January.
Thank you, Mr. Rees. Mr. Gucati, I wish to remind you, following what your counsel just mentioned, that you have the right to attend the status conference with your counsel. However, with your written consent and after receiving advice from your counsel, pursuant to Rule 96.2, the status conference may be attended by you in person, with your counsel participating via video conference link, by your counsel with you, Mr. Gucati, participating via video conference link, or it may also take place in your absence with your counsel present or participating via video conference link. I would just like to ask for the prosecution about the date for the status conference.
Any date would be fine for the Specialist Prosecutor's Office. Thank you, Your Honor.
Noted. I will issue a scheduling order very rapidly, and it will include the agenda in due course. After the status conference, I will issue a decision on the specialist prosecutor's disclosure obligations in accordance with Rule 102. In the scheduling order for the status conference, I will invite the parties to make written submissions before the hearing on this topic and on any matter that they would like to raise during the status conference. Mr. Gucati, as you remain in detention, I would like to inform you that you may challenge your detention on remand in accordance with Rule 57. As I provided in yesterday's rescheduling decision, I invite the defense for Mr. Gucati to indicate whether its request to postpone the time for the initial appearance hearing, which is filing F00079, filed as confidential, can be reclassified as public, or whether the defense intends to submit a public redacted version. Mr. Rees.
Would Your Honour allow us to consider that and make a filing at short notice confirming our position?
Absolutely.
I'm grateful.
Thank you, Mr. Rees. In this regard, I would like to remind the parties that filings should be submitted as public unless there are reasons to withhold information contained in the filing. In such a case, according to Rule 82, the party has to state the reasons for a confidential classification. Moreover, when I order a party to make submissions or indicate their views on the reclassification of their filings, it simply means that the parties are invited to state their views on this matter. Filing cannot be reclassified proprio motu by the parties, but only by judicial decisions. I also wish to note that I noted with some concern in the past few days that the media reported information regarding the date of the confirmation decision and the charges in the confirmed indictment that had not yet been made public at the time. In this regard, I would like to remind the parties and the accused to respect the confidential nature of some of the information in these proceedings. The initial appearance of Mr. Gucati takes place today at this time, further to an initial decision, and the second one, rescheduling time and date. While this time, taking in consideration that this is the initial appearance of the accused, I exceptionally allowed these changes, future requests for rescheduling hearings will be granted only for compelling reasons. Rescheduling a hearing involves significant additional work for several units of the specialist chambers, and therefore such instances shall be kept to a minimum. And on that note, I thank Mr. Rees for giving the availabilities of the defense with precision today, so we can schedule the status conference with a full knowledge of the availabilities of the parties. Finally, I would like to remark that the judicial recess begins on 21 December 2020 and ends on 1st January 2021. During this time period, I will only be responding to urgent matters. Non-urgent matters should be addressed to the Basic Court after the recess. Unless any party has anything to add, this concludes today's hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.